Yes, good morning, everybody.
All right, perfect. So Clinton, do you just want me to head straight into the first question?
Yeah, sure.
100%. All right. So the first question we've got from last week reads, who are you and why should we listen to you?
All right, thanks. Okay, so Rodemeyer Attorneys, I'm an attorney at Rodemeyer Attorneys. We are a law firm situated in Randburg. We are a firm that started some 15 years ago. The original starting partners are both specialists in intellectual property, and since then have branched out into every other field of law you can imagine other than criminal law. And yeah, so we provide a full range of services. It's everything from your intellectual property, which is your trademarks and your patents, through to commercial law, through to drafting of contracts, even family law, and then obviously we do deal with consumer protectionism and all the follow-ons from that.
All right, 100%. Then the next question for you this morning reads, what does the Consumer Protection Act state is an acceptable warranty period on labor?
Right. So you must bear in mind the Consumer Protection Act is a little bit vague when it comes to mentioning specific periods. There are certain returns policies in the Consumer Protection Act which it brought to the fore with regards to when you're buying goods. When it comes to labor, the question is a little bit different, and it doesn't provide you with a specific set amount of time. So what the Act says is that the consumer is entitled to expect from you good quality service, and that service or labor will last a reasonable amount of time, taking into consideration the specific circumstances of the work. So, well, basically what that means is that based on what you do, for instance, if you're fixing something that generally lasts a long time, let's say my clutch in my car, for instance, I don't expect it to only last 10 kilometers, but I don't expect it to last 30 years. So based on the work that you're doing or that you undertook for the client and the general amount of time that work is expected to hold before it needs to be touched up or fixed again is what you need to be guided by. So it just needs to be reasonable. It's very difficult to for them to just give you a prescribed period for every service that's ever offered, because different services are expected to last longer than others. But you must bear in mind that, you know, with regards to plumbing specifically, your work is inextricably linked with items in general. So generally, when you're fixing somebody's toilet, you bring parts with you to replace because the old parts are broken. Those parts need to then comply with certain standards. Some of them will just be, again, a restatement of a reasonable amount of time, but some might be specific periods. For instance, a 6-month warranty is minimum, or whatever the case might be. So that's about where it is with work. Unfortunately, they're not very specific with it. You just need to make sure that your work holds on for a reasonable period of time in the circumstances.
All right, perfect. Then the next question I have got for you is, if I use a non-compliant material and don't advise the client that there's a non-compliant, am I at risk in terms of the Consumer Protection Act?
Yeah, that's a good question. So the quick answer is no in terms of the Consumer Protection Act. So the Consumer Protection Act is there to protect consumers in general. So it doesn't deal with anything directly plumbing related. So it won't have any mention of compliance certificates or anything along those lines. It does not mention anything specific to any field at all. It's merely there to protect consumers in all industries. So it doesn't mention that specifically, but what you must bear in mind is that everybody who is a plumber who's taking it seriously is obviously registered with the PIRB, and the PIRB has a little acknowledgement that everybody has to take, which says that they will issue a certificate of compliance for every job that they do if it's above a certain value. For instance, I believe the value is 1,500 Rand, including all the materials, and for certain jobs that might be under that value but of a certain type, for instance, any sort of water heating system, they need to issue a certificate of compliance for every single one of the jobs that they do. And that certificate of compliance cannot be issued if one has used non-compliant materials. So the consumer may not be able to claim from you simply because you haven't used compliant materials, but you could find yourself being reported to whatever relevant authorities for not doing your work up to standard, potentially.
All right, perfect. Then I've got another question for you here, which reads, how do you handle the situation where Frankie's geyser is under warranty, but Frankie closed down the geyser section? Insurance company doesn't want to entertain the claim, and Frankie is giving you the runaround.
Okay, can you say that again? Sorry, I'm trying to follow the
Right.
names there.
Okay, not a problem. I am going to change it up just a little bit. How do you handle the situation where the supplier's geyser is under warranty? The supplier closes down the geyser section. The insurance company doesn't want to entertain the claim, and the supplier is giving you the runaround.
Right. Okay. So from what I can gather is you've got a warranty on that geyser as the plumber, and the one that you got from the supplier. The supplier no longer has a geyser section or department, and now their insurer does not want to replace the geyser. I guess that's your question. So you would have to then claim directly from the supplier. The supplier is the person who gave you the warranty. If they don't have an insurer that's willing to pay, you claim directly from the supplier. It doesn't matter whether or not they have a geyser department anymore. The fact of the matter is that they gave you a warranty on the product. For instance, if you have a company that sells you any kind of product, for instance, a TV, and they give you a 2-year warranty, and then the company decides they're no longer going to sell TVs, now they're going to sell radios, you still have a warranty on your TV, regardless of whether or not they're selling TVs anymore. So yeah, your warranty holds good. You can claim directly from the supplier rather than the insurer if the insurer has repudiated their claim for whatever reason.
All right, and then what would the steps be if the supplier still does not want to pay up, rather?
Okay, so the start of every matter for from an attorney's perspective is to send a letter of demand. Once you've sent a letter of demand, you give them the requisite amount of time. Generally, we give them 10 business days, so it turns into about 2 weeks. You give them a 2-week period to make payment or at least try and negotiate with you. If you receive nothing, your only alternative is then to issue and serve summons on them, take them to court, and claim in terms of that guarantee, that warranty.
All right, 100%. Thank you very much. The next question I've got for you then reads, what is the definition, or how does the law see a reasonable period of time, IRO, working delivery and warranty? So I think you just answered that question there.
Yeah.
All right, perfect.
Yeah.
100%.
I can go through it in general, but yeah, it's always just based on the circumstances. There are certain things that come with specific warranty periods, but in terms of your labor, again, it's a reasonable period of time.
All right, 100%. And the next question reads, last week you discussed the terms and conditions. These vary in terms of detail, or does the Consumer Protection Act have set guidelines?
Right. So terms and conditions are dealt with in the Consumer Protection Act. The Consumer Protection Act doesn't give you a set of terms that you have to use. they give you, the Consumer Protection Act gives you a set of terms that you can't use, if that makes sense. So it will say, there's historic terms that people always put in their terms and conditions. One that is important is, for instance, the foot stewards clause, where basically you sell something to somebody and you say to them, well, if it breaks, it's not my problem, it's your problem, and you can't claim back from me. So suppliers used to use that term very regularly, and it would really cost consumers a lot of money. So the Consumer Protection Act has really protected consumers from the foot stewards clause. They are no longer enforceable between certain parties. But the Consumer Protection Act doesn't tell you these terms must be in, and these terms, and this is how you must draft your terms and conditions, and they can't vary at all. Terms and conditions can be drafted to suit your business specifically, and you can amend them insofar as they do not conflict with the Consumer Protection Act. As I said, the Consumer Protection Act tells you what you can't do. So as long as you don't do what you cannot do in your terms and conditions, you can vary them to quite a great extent.
All right, perfect. And then we've just got a bit of a clarification on the previous supplier question. Is the supplier, is it the supplier or the manufacturer that is meant to take that warranty?
Okay, so in this relationship, you'll have your manufacturer of your parts, you'll have your supplier, which is the plumber, and then you'll have your consumer. So in this scenario, the consumer deals only with the plumber or the supplier, okay? So they are dealing with you directly. Their claim is against you. That doesn't mean, though, that you don't have some kind of fallback plan. If you buy parts from a manufacturer who provides you with a warranty of a year, and the consumer comes to you after 8 months and says, listen, this part has given me problems the whole way through, I need you to replace it. You then have to replace it. The consumer has a claim against you, but you can reclaim from the manufacturer. So your first step would be to contact the manufacturer and say, listen, this is the situation. I've got a faulty whatever, okay, that you supplied. You gave me a warranty of a year, and it has now been 8 months, and according to the consumer, it has been nothing but problems since the start. You can then go and inspect the part, see whether it has been damaged through the consumer's negligence. If not, then obviously the consumer has a claim against you, and you need to then tell the manufacturer, listen, on inspection, this is the case. You're going to have to give me a replacement part, or at least compensate me for replacing this one, and that's how you go about it. So you can't just tell the consumer, go to the manufacturer, it's not my problem. You must remember that the consumer didn't buy the part from the manufacturer. If the consumer contacts the manufacturer is going to say, I'm sorry, I didn't give you this part, so you can't claim under a warranty from me. It's the same as if I buy a TV from Game and it's a Samsung TV. If my TV breaks, I don't contact Samsung, I contact Game because I bought it from Game.
All right, perfect. The next question I have got for you reads, I did a small job for a client, and after 30 days with no payment, I contacted the client for payment and eventually handed it over to my lawyer. Once the client receives the letter of demand, he declares a dispute in terms of my charges, which then delayed the whole process and could not be finalized because I could not confirm statements made by the client with one of my employees. Is this process correct?
Right. So this is a bit of one of those situations where things have gotten very muddled up. So the process in terms of the claiming from the consumer through the legal method, that's all fine. Obviously, you have the right to approach an attorney. Generally speaking, if the amount is quite low, if you are going to get an attorney, you must just make sure of fees up front, because if it's, as you said, it's a small job. If it's only like 1,000 or 2,000 rand, you don't want your fees to exceed that, because you'll never recover all of your fees. It's just not going to happen. That being said, in this situation, if the consumer has a dispute with your charges, and they've told you, this is my dispute, this is why I don't like the charge, or whatever the case is, then obviously you should open yourself up to negotiating those charges with the consumer, because if you don't, they're just going to refuse to pay. It's much easier not to pay than it is to pay, and it's very difficult when it's a small amount for the plumber to claim the amount back, if the consumer is not willing. So in this scenario, I think everything seems to, obviously I don't know all the facts, but it seems that it went the right way, in terms of, obviously it's the wrong way for the plumber, but nothing seems to be very incorrect with the procedure that was followed. That being said, to protect yourself, you should always be aware of what your employees are saying to clients. If the employee didn't say the things to the client and the client is insisting, but the employee is insisting, then you're going to have to trust your employee and tell the client, sorry, that wasn't said, and you're going to have to sue the client if they're refusing to entertain your claim. That being said, we always try to strike a balance between negotiating and playing hardball, because generally speaking, if you play hardball from the outset, you're not going to get your money back. If you try and negotiate a little bit with difficult people, you can oftentimes get the majority of your money back, and they'll be satisfied with a small reduction in the price. It very much depends on what the dispute was in this scenario. So I'm not sure, what was charged, what was agreed beforehand, and what the client is saying that the employee said. Depending on what the client says the employee said, you should probably then just try and negotiate and say, okay, well, he said this, he says he didn't say it, so I'm prepared to offer you a 10-15% discount, because I'm not really sure what happened, and I want to maintain good client relationships, and I do need to be paid for this job in any event, because you obviously want something out of the job. You don't want nothing at all.
All right, perfect. The next question I have got for you is, what if your work guarantee is 12 months, but the geyser warranty is 5 years? Let's say the geyser then fails after 2. Can the consumer hold you as the supplier, in quotation, responsible? Your warranty to them has expired.
Okay, right. So in this scenario, you need to understand that there's a difference between the two warranties that have been provided. So I'll link this back up to the situation where I buy a TV from Game, and Game supplies me with a Samsung TV, and they give me a 2-year warranty. I don't claim under that warranty directly from Samsung. I claim from Game, and Game can then claim from Samsung, because Samsung says to Game, okay, we have good TVs, we'll offer 2-year warranty. Game offers the same to their clients. The clients of Game will claim from Game, and Game will claim back from Samsung. You must always remember that. You deal directly with the party with whom you dealt. So the consumer will always have a claim. If there's a 5-year warranty on that geyser, they'll come to you when the warranty, when they want to claim under the warranty, if the warranty is still good, right? You then contact the person who provided you with the geyser and gave you that 5-year warranty. Because obviously the manufacturer says, no, the geyser will last 5 years. And then they give it to you, and you give it to the client and say, the geyser will last 5 years. They got it from you, they will claim it from you. Another important thing to remember here is there's a difference between the warranty on the geyser and the warranty on the work. So it's a fine line, and sometimes you probably won't be able to always draw a distinction between the two. But you need to be very careful when you tell people what you are giving them a warranty for. So for instance, now you've been given a 5-year warranty for the geyser, and you put it in someone's roof, and you say, okay, the geyser comes with a 5-year warranty, and I give you a warranty in terms of my work for a year. If the geyser bursts in 6 months, are you saying that because it's in the first 6 months, you will replace the geyser at your cost, and you won't claim from the manufacturer under their warranty? You really need to draw a big distinction between the warranty of the parts and the warranty of the labor, and what a warranty in terms of the labor would entail. So in this scenario, the geyser burst. Obviously, you're not liable for the labor part, because the warranty under the labor warranty is expired. So whatever they would have claimed from you in terms of the labor, they can't, but they will claim, as I said, for the geyser from you, and you will then have to make that good and contact the manufacturer in terms of what I previously explained. So you contact the manufacturer and say, your geyser burst in 2 years, that's within the 5-year warranty, please can you replace the part? Okay, so that's how that works. But be very careful when you give a warranty on labor. It's very difficult for us to understand what you would then be giving a warranty for if you are a plumber. So if you install a new part and you say, I'll give you a 12-month warranty on the labor, what does that mean? Does that mean that the part won't fail? And if the part fails, does that mean that I can claim under that warranty for your labor? I would assume that in terms of this geyser, the labor that you would be giving a warranty for is the installation in the roof itself or wherever the geyser might be. So it's not going to fall out the roof. But again, you must be very careful when you tell people you give them a warranty in terms of labor, especially when you're installing a very expensive piece of equipment, because you don't want to be held responsible for that piece of equipment over and above, or at least then exonerating the manufacturer from their own warranties. You don't want to give a warranty in terms of the product. So just be careful in terms of your specifics about warranties.
All right, perfect. Then I'm still getting quite a few questions regarding the reasonable time for your work guarantee. Could you give us an example? Is it 3 months, 6 months, a year, right? What would be a reasonable period of time by law for the warranty of your work?
Okay, right. So as I said previously with the Consumer Protection Act, it's very vague, and that unfortunately does not come as any what's the word? It doesn't give any clarification to the suppliers, who are the ones who are ultimately responsible under the Consumer Protection Act. It is very much circumstantial, and that doesn't assist people who are lay people in terms of the law, and they're not lawyers. But a reasonable time period is something where you take into consideration the work that was done, the parts that were fixed, for instance, and what the function of the parts were. So if I have a toilet, for instance, and the pipe at the back there, that outlet pipe is broken, and you come in and you just repair that outlet pipe, okay? Depending on the nature of the original break, you know, if it was completely smashed and you said, no, we should replace it, and I said, no, rather let's just patch it up if it's possible. And you say, okay, if I patch it up, it could break again. Your reasonable period of time in that instance could be maybe a few days even. In that scenario, your guarantee or warranty period in terms of your labor would not be long, because you told the guy, listen, you need to replace it. And he said, no, I want you to fix it and see if it works. Then if it breaks after a few days and he says, no, man, your work was shoddy, then he wouldn't really have a claim, because you told him this is the situation, it might break, and in those circumstances he should have got a replacement. If you replace the part, you must understand that the part itself will come with a warranty period where they can return it or whatever the case is, and generally that's 6 months. In general, for each part it's about 6 months that they have a chance to at least return the good. If it breaks within the first within those 6 months, then you have to replace it. If it breaks, you have to repair it first if it breaks the first time. If it breaks again, you then have to replace it completely. And if it breaks again, they have the opportunity to receive their money back and get somebody else to do the job for you. It's very difficult to differentiate, again, as I said, between parts and labor. The part itself comes with protection, and that period is generally 6 months. The labor, you can stipulate in your terms and conditions how long you will guarantee your labor, but you must be very specific with what you mean when you say, I'll guarantee my labor for this period of time. But if you're going by the Consumer Protection Act and you're going for the reasonable period of time, you need to take the factors, the entire circumstances into account. So as I said, if it's something that you would expect to last for a 3-year period of time and it lasts 3 weeks, they're going to be able to claim from you. But if it's a part that breaks often, or a part that's very unreliable, or they've insisted on a repair instead of a replacement, then you're not going to be held accountable for 3 years. You might be expected to at least allow it to last for 3 months, or for even a month if it's something that's really faulty. As I said, it's circumstantial, and I know that doesn't always help people, but you have to look at it and be reasonable about it. So you look at the situation, you say, if I were in this consumer's shoes, would I expect this to last longer? How did I explain the entire situation to the consumer? If you were very upfront and you told them from the start, this is not a good idea, I don't think it's going to last very long, then they're going to have no claim, because you told them right up front, this is the situation. If you do it this way instead of the way I've suggested, then I'm not going to be able to guarantee anything functioning for any period of time. But if you've given them everything completely new, then you'll have a period of time of at least 6 months where it needs to be working.
All right, 100%. Guys, unfortunately, we are not going to get through all of the questions this morning. Clinton, I am just going to ask you one more question, and then the rest of the questions I'll send to you so that we can get them answered via email. All right. Yeah. What looks to be the last question I'll ask this morning reads, if the client does not pay the required amount, can I remove the equipment that I installed?
Right. Okay, so we've had this we had this question last week, I believe. So this is a situation, and it happens very often. Terms and conditions generally will say that the plumber retains ownership over all parts until such time as payment has been received in full. Now, that's all very well and good, but that does not entitle you to enter upon somebody's premises without permission and remove items that you've put in, unfortunately. It doesn't allow you to do that. It allows you to claim it through the proper legal procedures. You'll have to sue them. You can say, you can send them a letter and you can say, listen, you haven't paid in full, we need to collect our goods. The fact of the matter remains, if they don't allow you onto the property to collect your goods, you can tell them we need to collect the goods. If they allow you, 100% you can take it. But if they refuse to give you access, you can't break into their property and take the goods yourself. You have to follow the correct legal channels, and that will be through instituting legal action and claiming it back. But in general, if you're going that route, then you would just ask for payment. You would claim payment from them in the legal action instead of claiming back the parts that they've now used, because obviously the parts have now been used and you're going to be losing money. Rather than when you claim payment from them, you'll be claiming your full payment that you would have got, which is your profit margin, obviously. So that term is very common, but it doesn't allow you to take the law into your own hands. And if you do, you can really suffer big time at the hands of the law if you go and do something like that.
All right, well, perfect. It has gone 07:30, so unfortunately I can't ask any more questions to you this morning. Clinton, is there anything you want to say just to quickly end off the session from your side this morning, very quickly?
Yeah, look, I mean, I think if the people that are asking questions this week haven't already watched the session from last week, perhaps go and watch that session. We did deal with some of the questions that were asked today in that session, and I think we had a little bit more time that last week, because obviously this week we've been dealing with some more complicated questions and some more specific questions. So perhaps go back and listen to last week's one, and then obviously next week we'll be dealing with some more specific issues, and we'll actually be giving a full presentation on specific issues and the terms and conditions next week. So again, also next week, please tune in, because that's probably one of the most important things, is your terms and conditions.
All right, perfect. Thanks so much, Clinton, for joining us this morning. Then I am going to go ahead and end the session off now. Guys, I have been sending through, I'm going to send it through again. It is a link to last week's CPD assessment, right? If you do go onto the App Plumber or the IOPSA YouTube page, you can view the recording from last week. Right, go ahead, watch that recording, and on both platforms is the assessment as well. Guys, please note on that assessment you have only got one chance. You can only open it once. So please go ahead and take that CPD test when you are ready for it. Other than that, guys, I am going to go ahead and end the session off now. Please remember the survey on the way out and enjoy the rest of your week, guys. Thanks so much. Bye-bye.